Hi, this is Scott Pierce. Today's seminar covers evidence, and now all of the subjects are going to start getting easier. In my judgment, evidence is one of the easiest subjects on the essay section on any bar examination, and California is no different. Evidence, by its nature, is a lot more difficult on the multi-state. On the MBE, they can split hairs. The National Conference of Bar Examiners can draw up questions so that answer picks are very close to one another. But here, on the essays, they've got to give you the issues in a pretty straightforward fashion, and our job is to be well organized mentally so that we can be quick on the draw. One thing that makes these evidence essay questions difficult, to the extent they are difficult, is not the intellectual content of the questions, but the number of issues. Sometimes it is very challenging to finish an evidence answer under time constraints. And the most common mistake that candidates make, of course, is to spend too much time reciting the law and not enough time engaging in factual analysis. So the big picture of evidence can be summarized very, very quickly. For essay purposes, there's 3 steps. Step 1, establish relevance. Step 2, raise as many objections as can be raised. And then step 3, reach a conclusion with regard to admissibility. Should this evidence come in or not? Okay, that's the big picture. Let's take a look at the approach that I present and focus on a few subtleties. At the beginning, you'll see that I do what most other scholars who have spoken about this subject do. I divide relevance into logical relevance and legal relevance. I think it's almost always appropriate to begin with logical relevance and to state in your essay what the evidence is. Identify the evidence, and then very specifically explain why it matters. What does the item of evidence tend to prove? And remember, many items of evidence which are logically relevant end up being inadmissible anyway. So we must always begin by considering logical relevance. Then, after that, it's time to get into objections. And there are objections that involve relevance. The first, an obvious one, is that, in fact, the item of evidence is irrelevant and that it doesn't tend to prove anything at issue in the case. And that objection does occur on essay questions, but it isn't terribly common. Far more common are objections that involve relevance. First, on my list, you'll see practical objections involving relevance. And here, I've put the character evidence issues, habit and routine practice, and similar happenings. We'll look at all of these issues, and it's easier to explain them in the context of an actual fact pattern. Then there are policy objections that involve relevance, subsequent remedial measures, liability insurance, offers to compromise, payment of medical expenses, and criminal pleas and plea bargains. Now, all of these are tested on the essays, but by far the most common are questions of insurance and questions of subsequent remedial measures. So what's important to remember, both about the practical and the policy objections involving relevance, is we are mostly stipulating as to the logical relevance of these items of evidence. Certainly, the fact that a party may be insured could tend to prove something of consequence to the jury. But still, for public policy reasons, we keep these details out of the province of the jury room. So once we're finished with relevance, both logical relevance and any possible objections that involve relevance, then we move on to the meat of evidence, the objections. And by far the most commonly tested is hearsay. You'll see that I include up front one idea which isn't really part of most definitions, but can play a nice role in essay answers. And that's the idea that the reason hearsay is objectionable is because it is not subject to cross-examination. Notice also that there are many items which actually fit the definition of hearsay, which are deemed non-hearsay under the federal rules of evidence. And you'll see that I list these. Also, there are objections involving privilege, and these also are commonly tested. probably not nearly as commonly tested as hearsay, but still very commonly tested. And note that of the privileges, the marital privilege and the attorney-client privilege are by far the most commonly tested, and we're going to have a good look at both of those objections in this seminar. Also, take a step back for a minute and keep in mind that evidence often is crossed over with other subjects, and other subjects are crossed over into evidence. So when we consider the attorney-client privilege, we should be aware that there might be professional responsibility issues tucked into the evidence problem. Also, the Fifth Amendment right against self-incrimination also can be considered a type of privilege. And remember again that whenever an evidence question arises out of criminal court, it's quite possible that objections will be raised by the defendant which really come out of the law of criminal procedure rather than the law of evidence. Remember, in crim pro, exclusionary rule issues can be connected to the Fourth, Fifth, Sixth, and maybe even the Eighth Amendment. And as we go through together and look at a couple of questions that involve criminal law, I'll show you again how this plays out. And I'll remind you of this comment as we review the individual essays. The issue of competence as an objection is one that isn't heavily tested on the essays, and perhaps that means you'll see it more than once over the next year or two. Competence has been raised in more than one performance examination involving evidence, and it makes sense that it would do so, because the performance examination allows for a greater degree of complexity and a little bit more time to think through the issues. Next, with regard to objections, I consider opinion, and opinion also is a very commonly tested objection, as we'll see together in the not-too-distant future. Next, I consider impeachment and rehabilitation of witnesses, credibility issues, and basically, here, all we're talking about are the methods of impeachment and the methods of rehabilitation. I list them. You should be aware of them. Now, keep in mind, I am not suggesting that you memorize this list with some hope that in the future you'll be able to cough it all back up. I'm going through this list to make sure that you understand all of it, and to make sure that you see these issues arising in a context that makes quite a bit of logical sense. As someone who has spent all of his lawyering years practicing as a litigator, I can tell you that evidence and civil procedure both make a great deal of sense, and they aren't counterintuitive, although certainly there are plenty of complicated issues in both subjects. After we consider issues of credibility, I move on to consider physical evidence, so-called real or non-testimonial evidence. Here we consider documents and physical and demonstrative evidence and scientific tests. Often, this will be tested in conjunction with expert opinion testimony, where we get some person on the witness stand to interpret the results of the tests. Also, authentication and chain of custody issues are more commonly tested on the multi-state than on the essays, but it's well worth your time to be sensitive and aware of them so that if they show up, you'll know what to do with them. And then, finally, we get to admissibility. Now, one would think, perhaps, that admissibility is pretty much a one-liner. Either yes, it comes in, or no, it doesn't. But notice, I include here a few additional details. An issue of notice, one that's been tested more than once in recent years on essays. The mechanics of eliciting testimony, examination and cross-examination. The roles of the judge and jury instructions. Now, with regard to examination and cross-examination, California, over the last couple of decades, has been a national innovator in more than one way on the bar exam. California invented the performance test, and for essay questions on evidence, California has introduced a novel format, and that format is to provide a brief trial transcript and to ask about objections. And we'll take a look at more than one of those during our work together. So, let's get into evidence. The bottom line, evidence is easy to organize, and it's more commonly a racehorse question than a question that will be confusing or require knowledge that is esoteric and out of the mainstream. Evidence is a simple subject. It is tested in a ritual fashion, over and over again. The same issues come up. In the same way, the work that you do on this subject can pay big dividends, because if the bar gives you an evidence question, you can rest assured it will be strikingly similar to one that you will see here.